I've been asked to speak sort of about the practical nuts and bolts of challenging the HHS mandate. There are currently some 30 lawsuits that have been filed against the mandate. Most of those have been filed on behalf of religious institutions or ancillary institutions connected with a religious institution. To give some examples, the first lawsuit was filed by Belmont Abbey College, a small Catholic college in North Carolina. However, they've been joined by Notre Dame, which I'm sure you've heard of, Franciscan University, EWTN. Non-Catholic colleges have also sued, such as Wheaton College in Illinois, Geneva College, Louisiana Baptist. And also, in addition to colleges and organizations like EWTN, several dioceses and archdioceses filed suit recently. And in fact, those lawsuits are being added to almost on a weekly basis. So, for example, you have the Archdiocese of New York, of Washington, Diocese of Pittsburgh, Dallas, Fort Worth, Fort Wayne, Joliet, Peoria, and most recently, the Diocese of Nashville, along with several Catholic organizations associated with, or at least located in those dioceses. The other lawsuits that have been filed, and these are the ones that I've been involved in most closely, are the private employer lawsuits. And these are the lawsuits that may be of the most interest and relevance to this audience today. We at the ACLJ filed the first of these lawsuits on behalf of an individual named Frank O'Brien, a businessman in St. Louis, and his corporation, O'Brien Industrial Holdings. However, the case that's gotten the most news coverage, and rightly so, is a case out of Colorado filed by the Alliance Defense Fund on behalf of a family called the Newland family, who runs something called Hercules Industries, an HVAC company. But in addition to those, a company in Michigan, Weingart Supply, has also sued, and most recently Hobby Lobby, a rather large 22,000 employee company, sued, I believe, just last week in Oklahoma. What are the legal bases of these claims? And I'll quickly go through those because Christopher has covered, I think, the most important legal basis, which is RFRA. But just to run down what every one of these lawsuits has in common, we all allege that the HHS mandate violates RFRA, the Religious Freedom Restoration Act. But most of the lawsuits, in fact, I suppose all of them do, also allege that the mandate violates the First Amendment's Free Exercise Clause, which Chris also talked about, the Establishment Clause, and the Free Speech Clause. The Free Speech Clause comes into play because part of the mandate is not only that you have to pay to supply contraceptives, sterilization, including abortifacients, but also that you have to pay for patient education and counseling about those things. And I don't think the HHS means to counsel people against using them. Therefore, it's a form of compelled speech, requiring an employer to subsidize speech that the employer disagrees with. And every case also has a claim in there that the mandate violates something called the Administrative Procedure Act, which is kind of a catch-all that says a regulatory agency such as the HHS cannot pass a regulation that violates a statute which would be above a regulation on the hierarchy of laws. That's a fairly complicated claim, and I'm certainly not going to waste any of your time on it. But let's talk about where these cases are and where they're likely to go and what the likelihood of success is. The bad news is, at least for now it's the bad news, that the religious institution cases are being dismissed by the courts. So far there's been 3 rulings on those cases, and in each case the courts have dismissed them. Not on the merits. In other words, no court has yet said that the HHS mandate doesn't violate RFRA or doesn't violate any of these constitutional provisions. But what they're saying in these religious institution cases is that it's too early to make a decision. And the reason they're saying that is because of this temporary safe harbor that's built into not the original HHS mandate, but into sort of tweaking of it that the government has done every time there's an uproar and every time people are threatening to sue. So in February of this year, although the mandate's been around since July of 2010, really, in February of this year was when HHS and the President and Secretary Sebelius came out and said, okay, we hear what you're saying about religious institutions. We're going to think about it some more. And so you religious institutions don't have to comply with this for another year. And that was even subsequently modified in March when HHS came up with something called Advanced Notice of Professional Rulemaking, which expanded that temporary safe harbor with regard to religious nonprofits to August 1st of 2013. So courts that are confronted with these lawsuits by religious employers understandably have a way out, because this is a controversial issue, and if you're a judge that's not interested in making a controversial decision, it gives you a pretty good reason to say, let's wait and see what the government does. This is a moving target. You say that the mandate will require you to do this, Wheaton College or Belmont Abbey College, but we don't really know what the mandate's going to require you to do because HHS is still tinkering with it. And in fact, by the time August 1st, 2013 rolls around, you may not be required to comply with it. So why should the court make a definitive determination of these really basic, profound constitutional questions when there may be no reason to? It's an understandable position by a court, but anybody that's practiced in this area understands these concepts of ripeness, which have to do with it being a premature case. And the rule of thumb, which is really not a rule of law, is that if the judge wants to decide your case, it's ripe. If the judge doesn't want to decide your case, it's not ripe. It's almost that subjective. So, what happens in the cases of the private employers? Well, the good news, bad news is, the bad news is that the mandate applies to them now. The good news is the courts really can't evade the responsibility of adjudicating the challenges that have been brought. And in fact, there has already been one, at least preliminary ruling in one of these cases, and it's the Newland case that I mentioned at the outset. This is the case filed in the Federal District Court in Colorado on behalf of the family, a Catholic family in the HVAC business. They brought a motion for a preliminary injunction, and the court in that case granted the motion for preliminary injunction, much to the surprise of some of us who recognizing that the judge in question was appointed by President Carter. In fact, I've argued before this judge and assured the attorneys for the Newland family that there was no way they would get a preliminary injunction, which shows how much I know. But this judge, and I think Chris sort of alluded to this, this judge took an honest, fair, objective look at the legal arguments, really only the RFRA argument, he didn't address the other arguments, and made some of the points that Chris has made and that I'm about to make, that they don't have much to say against the RFRA argument. In fact, the government ends up looking kind of silly when they try to. What does RFRA say? RFRA says that the federal government may not substantially burden a person's exercise of religion unless it shows that the application of the burden to that person, this is very important, not just generally, but to that person, that the application of the burden to that person is the least restrictive means of advancing a compelling interest. So, and I'll tie this into the ruling in Newland because this is exactly what the steps that the judge took. Not all of these in as much detail, but basically this is what he decided. So is the HHS mandate a substantial burden on the religious exercise of a business owner? What the court in Newland said was, the government says that a business, a corporation, cannot exercise religion. Individuals can exercise religion. A business doesn't have religious beliefs. What the judge said, and I think I can tell you why the government's wrong in a minute, but what the judge said, I'm not going to touch that. It's a close question. I don't have to decide it. If it's the case that a business can exercise religion, then I've got to proceed to the next step, so I'm going to do that. But here's the problem with the government's position as far as this not being, and the government also says it's not a substantial burden on a business owner to pay for contraceptives or sterilization or abortifacients in violation of their religious beliefs. Here's the problem for the government. The government itself recognizes that the HHS mandate imposes a substantial burden because it exempts religious institutions, at least some religious institutions. It doesn't exempt them because it likes religious institutions. It exempts them because it recognizes that they have a burden on their religious liberty in paying for things that violate their sincerely held religious beliefs. So the government can hardly with a straight face say, this can never be a substantial burden on someone when the government itself has recognized that it is a substantial burden by granting exemptions. The next step is it a compelling interest? Is it a compelling interest that the government require every employer to pay for contraception? Is the free access to contraception, universal access to free contraception, no co-pays, no deductibles, is that a compelling interest? Well, here's the problem. Written into the Affordable Care Act is something called the grandfather clause. And this was made a big deal of by the president when he was campaigning for this law. I believe his statement was, if you like your health care policy, under my law you can keep your health care policy. And what that meant was, written into the Affordable Care Act is this provision that says, if you haven't changed your policy after whatever the effective date of PPACA was, I think it's March of 2010, as long as you don't change it, you don't have to change it to meet the requirements of the Affordable Care Act. And that includes this preventive services mandate, which we call the HHS mandate. And the government, and this is really a political calculation, in other words, in order to sell the Affordable Care Act, they had to make it as non-scary as possible. And so if you want to keep your policy, you can keep it. You don't have to do anything. But here's the problem, as the government itself points out, and as the judge in the Newland case pointed out. But the government's own estimate, that exempts potentially 98 million people. So the government itself, and there are other estimates that it exempts. In fact, Judge Kane in the Newland case said 191 million. I'm really not sure how he did that math, since that's at least 2/3 of the American people, and not all of them are employees. But anyway, if it's 98 million or 191 million, it's a whole lot of people that aren't covered by this law. So how can the government coherently argue that they have a compelling interest in free access to contraception when their own law says basically 100 million people don't come under its protection? That's a big problem for the government. And then, of course, there's the least restrictive means part of this analysis, which Chris alluded to, that forcing employers, including objecting employers with religious objections, forcing them to pay for their employees' contraception is the least restrictive means that the government can accomplish its goal, its compelling interest, of universal access to contraception. And of course, the response to that is, wait a minute, there's not a less restrictive means, there's not a means that doesn't impinge upon individual religious objectors. What about the government giving it away like it already does? Through Title 20, Medicaid, other government programs, contraception is essentially free in this country if you meet certain income criteria. Well, what's easier, lowering the criteria or even eliminating the criteria if this is truly a compelling interest, or forcing the Archdiocese of New York to pay for something that it morally objects to, or forcing Belmont Abbey College to pay for something that it morally objects to, or forcing Frank O'Brien or the Newland family to pay for something that they have a moral objection to. So that's the essence of the RFRA argument. And that is what the court in Newland essentially held. In granting the injunction, Judge Kane said, the injunction is granted because the mandate likely does substantially burden the Newlands' exercise of religion by forcing them to pay for things they find morally objectionable. As I said, he didn't make a final determination on those issues, but it said likely it does substantially burden them. Second, the government cannot show a compelling interest when it allows what he referred to as, quote unquote, massive exemptions from the mandate. The grandfather exemption, that's not the only one, although that's only 100 million people. There's also the religious employer exemption, which covers who knows how many people, probably another 10 to 20 million people. And there are other minor exemptions to the mandate as well. So the government cannot say that there's a compelling interest when it grants, quote unquote, massive exemptions. And finally, the government cannot show that the mandate is the least restrictive means because, as Judge Kane pointed out, and which every, I think, fair-minded observer has pointed out, the first one that springs to mind, and it's by no means the only one, is the government can give the stuff away for free like it's already doing. It can just change the criteria for getting free contraception. So, I want to caution you, though, about putting too much on the Newland preliminary injunction. I mean, we've all trumpeted it as a great victory, which it is. But you have to understand that the judge's caveats were that the judge is not deciding the basic fundamental issues of constitutional law or even RFRA at this time. He said that the following questions were what he called difficult and of first impression. Of first impression just means there's no legal precedent for it one way or the other. As you probably are aware, just from general knowledge, when courts decide cases, they look to legal precedents, usually the precedent of the court above them. In the case of a judge sitting in the District of Colorado, he's looking to the 10th Circuit Court of Appeals, where Colorado is, and or the U.S. Supreme Court above the 10th Circuit Court of Appeals. And what he's saying is there's no precedent one way or the other on these specific questions. So gives a judge a lot of room to be creative, and they try to look for analogous precedent, but it's an issue of first impression. I'm more concerned about the fact that he called it difficult, because we're arguing, of course, that it's not that difficult. But here's the difficult questions. Can a corporation exercise religion? Should a closely held corporation owned by a small group of religious-minded individuals be treated differently than a publicly held corporation operated by stakeholders with diverse beliefs? And 3, is it possible to pierce the corporate veil and disregard the corporate form in this context? Those are questions that he's going to decide. He thought there was enough here to grant a preliminary injunction now, but he specifically limited his preliminary injunction to 3 months after he makes a final decision on the merits. So it's a great decision. It shows what even a judge who on paper you would not think would be ideologically inclined to our position did when confronted with the arguments that our side is putting forth and confronted with the arguments that the government is putting forth. And we're hopeful that this can be translated specifically into the O'Brien case, which we're in the process of briefing right now. We have a preliminary injunction filed, and our final brief is due Monday. Hopefully people back in the office are working on it. I know they are. And the other cases. In addition to the 4 that are already on file, we in our organization have 4 others ready to be filed in different jurisdictions around the country. And what we're finding invariably is that you have a Catholic or other Christian business owner, sometimes who didn't even really know what they already were covering under their health care policy, which presents a little bit of a tricky problem legally, who provides health care insurance for their employees. Generally, these are people who operate their businesses in accordance with fixed ethical principles that they derive from their religious beliefs. Some are more open about that than others. For instance, Frank O'Brien, and this was new to me. I'd never seen this before in a secular business. When you walk into his lobby in St. Louis, there's a big statue of the Sacred Heart. When I was drafting the complaint, I asked Frank, Frank, what year did you put that up? Because I need to, I want to put that in the complaint because it shows that you're really a religious guy. He said, well, actually, the Protestant previous owner put that up. Oh. Okay, only in America. But he kept it up. But in addition to that, when you go to his website, there are statements of religious principles. There are statements of how the employee benefits that he provides are inspired, at least in a general sense, by his desire to run his business in conformity with his Catholic religious beliefs. And other business owners we find to be similar, although maybe not as overtly, quote-unquote, religious as O'Brien. And I'm not sure, and this is something that I'm sure will have to be litigated, that in the absence of any sort of ethical or religious statements by a business employer, I'm not sure how much that would weigh into a court's decision about whether a business can, quote-unquote, exercise religion. It helps, I think. So that's where we see these cases going. Again, what can change to pull the rug out from all these cases? At first, we wondered about the Supreme Court decision. And when we were being consulted by not only business owners, but by religious institutions, because we had written some comments on behalf of the Dominican Sisters of St. Cecilia in Nashville, otherwise known as the Nashville Dominicans, they were very cautious about, well, let's wait and see what happens with Obamacare. And of course, we know where that went. Because had the court struck down all of Obamacare, this would have gone with it. And the next hurdle for a lot of folks is the election results. And obviously no one here can predict where that will go. If you can figure out a way to get South Dakota another 100 electoral votes between now and November 6th, it might have an impact. But since we don't know, and we just have to assume that this thing will be around for the foreseeable future and will only get worse. There are things in the Affordable Care Act itself that were, I think, held back, tempered. Even this grandfathering provision was a political fix would not be surprised at all to see those things fade away in a next Obama administration, which doesn't have this sort of political accountability. So where do we go from here? And I've been asked to address what are the costs to businesses, specifically organizations that decide to pursue this. The legal cost should be zero. I mean, we are a pro bono, nonprofit legal organization. We don't ever charge clients for our services. There are other organizations like ours. In fact, other organizations have actually more cases on file already than ours. The Alliance, I think they're the Alliance Defending Freedom these days. They changed their name, but they're still the ADF. They have the Newland case. They have a couple of others. There's the Beckett Fund that has most of the first sort of institutional clients, such as Belmont Abbey, EWTN. And then actually, there's a firm in D.C., Jones Day, one of the largest firms in the country, actually, that has taken the lead on the diocesan sort of Catholic religious institution cases. And I know for a fact that they're working in conjunction with the USCCB, and I've been in consultation with the general counsel for the USCCB throughout this whole thing, trying to coordinate a strategy that will get good cases throughout the country in different jurisdictions. And the reason that's important, it's not just because it's great to have a lot of cases. The way the court system works, and again, this is something you may realize from general knowledge, it's great if the district court in South Dakota strikes down the HHS mandate, but it won't have much of an impact, although it will have some, even in North Dakota or Minnesota necessarily. So the way the federal court system works, precedent comes mainly from the circuit courts of appeals because the Supreme Court decides so few cases each term. So most of the judge-made law in this country is at the Court of Appeals level. Of course, they always have to be guided by Supreme Court precedent if there is any on a particular issue. So you want cases decided at the Court of Appeals level, and the way they get to the Supreme Court, for the most part, is when there is a conflict between the circuits. It's not the only way. The Supreme Court can decide that an issue is of great public importance and can take a case even where there is no dispute in the courts below. But generally, and this is exactly what happened with the Health Care Act itself, there was a split among the circuit courts of appeals, and so the Supreme Court steps in and says, this is a matter of great public importance. The courts below can't agree. This is our job. This is what we were made for, to resolve these kinds of disputes so that there is a uniform rule of law throughout the United States. That's why it's good to have cases everywhere. And this is just legal strategizing. You know, it's good to have your case if you're a businessman or businesswoman who's being forced to comply with a law that's unjust and that violates your moral beliefs. But big picture, looking at the big picture, it's good to have as many cases as possible so that we can get as many decisions as possible. Cost to the organization, as I said, the legal cost, minimal. A lot, well, none really in terms of paying for a firm to represent a business. Some business owners have raised the question with us, what about retaliation by the government? Frank O'Brien's people, you know, what about OSHA? We get visited by OSHA a lot. Are we going to get visited by OSHA every week? IRS, that sort of thing. Well, we filed the O'Brien case in March, and OSHA is still coming in as often as it did before. It's hard to believe that the government would be that dumb, but, I mean, I suppose you can't rule it out. But it's clearly, you know, when you attack the government, I suppose you might lie awake, as if you don't lie awake enough when you're running your own business, worrying about things. This might be just one more thing to worry about. I don't think it's that serious a thing to worry about. If it became clear that that was the motivation for any sort of government, even just inspection, and we saw a pattern of that, that would be an even better case than the case challenging the HHS mandate, and a really fun one. But at least for the lawyers. I understand, maybe not for the business owners. I liked what Fulvio said at the end of his talk about businesses or business owners are called to be heroes. And I think I share that sentiment, and I think that's true in this situation. It's really kind of scary and chilling when I read the government's briefs in the O'Brien case and in the other cases where the Department of Justice, which represents the United States of America, is taking the position with nothing equivocal about this position that only religious people enjoy the right to free exercise of religion. And when they say religious people, they don't mean you or you as a citizen who has strong religious beliefs, they mean officially religious people. Priests, rabbis, preachers, only churches, only formally organized churches have religious freedom, which of course is not ever what the framers intended. But beyond that, the exemption that they've written into the mandate spells out what they mean by that. Not even what we think as religious people enjoy religious freedom. So for instance, you would think, why does the Archdiocese of New York have to sue? Why does the Archdiocese of Washington, Pittsburgh, et cetera, et cetera? Why do they have to sue? Surely they are religious institutions. Well, not necessarily under the religious employer exemption written into the mandate. And why is that? Because one of the criteria, and I think they fail probably more than one of the criteria is that they primarily serve persons who share their religious tenets. What a contradiction to the commission of Christ in the gospel, to preach the gospel to all nations. And there's not a Catholic diocese or archdiocese that, and I think it may have been Cardinal Dolan who asked this, we don't ask to see anybody's baptismal certificate when they show up at a Catholic Charities soup kitchen, or when they show up for Mass, for that matter. That's not what the Catholic Church is all about. It's not what many other, probably most other Christian churches are all about, and even many non-Christian. But that's what's really scary about this, and I think that's why it has to be challenged. So if even the Archdiocese of Washington is not a religious institution, according to the United States government, then those of you sitting here who may have a business that you run, who think, well, although I don't have Mass said on the premises, I don't have statues in my lobby, but I want to run my business in a way that at least is consistent with my Catholic or whatever religious beliefs. The government's saying you don't have a right to do that. That, I think, is one of the many things that makes this worth challenging by the private employers. And I would encourage those of you who are private employers to consider getting involved at that level and really be the kind of heroes that I think we really need in this country at this time. Thank you.